So you've gotten that middle of the night unexpected call and it startled you from sleep. You may not even be awake enough to think clearly. And that's when people make the mistake of saying, "What happened?" No, never. Hi, I'm Central Florida attorney Dione Talkington Fletcher, and today I'm answering commonly asked legal questions. First to remember, every accused person is presumed innocent and entitled to a speedy trial, and the court will often release a person on their own recognizance, i.e. without having to pay, if they have substantial ties to the community. The Constitution also prohibits excessive bail. Now, if there is monetary bail, it's done in two different ways. The first is by posting 100% of the listed bail to the clerk of court by the surety, that's the person who paid the money, or two, using a bail bondsman by paying 10%, which is the premium. Bail bondsmen's offices are located usually pretty close to the jail, and many offer 24-hour service. Now, if the bond is fairly high, the bondsman might request collateral for the difference. The answer is it depends. Many cases, many charges have a preset bond amount, usually in increments of $250 or $500. And as soon as the person is fully booked, they can go ahead and post. Now, if it's a more serious case or the charges involve violence, the person will be brought before the court within 24 hours of arrest. Now, the judge may impose some non-monetary conditions in addition to the cash bail. These could include electronic home monitoring. There is a fee for that. No return to place, no contact orders. And no contact truly does mean no contact. Social media, texting, phoning, sending messages through friends, all of those would be prohibited. Usually there is a prohibition on returning to the place that the alleged crime occurred or returning to someone's workplace, place of school, or home. The court usually also imposes no use of alcohol or use of non-prescription medications. So you've gotten that middle of the night unexpected call and it startled you from sleep. You may not even be awake enough to think clearly, and that's when people make the mistake of saying, "What happened?" No, never. There are only two questions to ask when you receive that call from a dear friend or loved one. What county, what jail are you in, and has bond been set? If you ask something like "what happened," you're asking the accused to give up facts that might be used against them later in a trial and could be misconstrued, so do not do that. Now, if you have any doubts about whether or not that person is going to keep their promise to show up for future court appearances, think twice before posting the bond because you could lose that money. Once a case is finished, whether that means the charges were dismissed or your attorney negotiated a satisfactory plea agreement or you were found not guilty at trial, the judge will order cash bail posted with the clerk of court to be returned to the surety. That may mean that any restitution funds or court surcharges are deducted from that, but it will be sent in a check back to the person who posted it. If it was a bail bondsman, you don't get the premium back, but any collateral the bail bondsman required will be returned to you. Last note, make sure that if you move, you update your address with the clerk of court as well as your attorney so that you don't miss any court appearances. Thanks to all who sent in questions. I enjoyed them.